Sheila Gunn Reid for Rebel News, and for the past 3 days, I have been covering the federal court hearing of our Rebel News lawsuit against Justin Trudeau's COVID jail system. Now, for those of you who don't know, in Canada, but only if you're flying into the country, you first have to present a clear COVID test within 72 hours of takeoff. Then when you arrive here, you have to submit to another COVID test. And then after arrival, you're taken against your will to a COVID jail, a hotel facility, for another 72 hours while you await the results of that second COVID test. And then once you get the results, whether they are negative or positive for COVID, you still have to go home and then quarantine for 14 days. Oh, and the kicker here, you have to pay for your own hotel stay that you were taken to against your will when you could have just went straight home. However, if you turn up at the airport presenting COVID systems, then you can go straight home to quarantine. They don't want you at the COVID jail if you're sick. The COVID jails are strictly just for healthy and presumed healthy people. One of our former journalists, Cian Bexty, was taken into a COVID jail after he returned from reporting on a story in Florida. Now, in a free country, you don't take innocent, healthy people off to jail. And that's why we're fighting this COVID jail system in court. We're suing Justin Trudeau. You can see all of our coverage and support our ongoing David and Goliath battle against the endless resources and money of the Liberal government at nocovidjails.com. Now, today was the government's turn to make arguments in support of their COVID jail system. And I should note that the federal government has adopted completely all of Rebel News's evidence and records. Government lawyers argued today, well, several different things. First, lawyers for the government argued that the Section 6 charter rights of Canadians to enter and leave and travel within our own country are intact despite the 72-hour hold it puts on people who are just trying to fly back home. Government lawyers said that Canadians still have a choice whether or not to return or leave, and that a disincentive to leave or return to Canada does not constitute a breach of our Section 6 charter rights. But truly, friends, if the options are to return home and then go straight to jail, though you're innocent and healthy, or stay gone from your own country to avoid that 72 hours of airport incarceration, is that really a choice? Now, at one point, Chief Justice Crampton asked about Rebel News's former reporter Cian Bexty's affidavit, where he swore that he was exposed to 14 additional individuals in the COVID jail that he would not have been exposed to had he been allowed to go directly home to quarantine for his 14 days. Government lawyers said Bexty didn't give those details about those close contacts and how and where and when he had contacted those people inside the COVID jail. But it's important to note that the Attorney General lawyers never bothered to cross-examine Cian on his affidavit, so they could have learned that information from him at any point. Lawyers for the government also said that there was no evidence that the 14 additional contacts Cian experienced inside the COVID jail exposed him to any sort of additional COVID risk. However, the whole point of the COVID jails, so they say, is to minimize exposure and risk. So in this instance, it's obvious there were extra exposures in Cian's case. Lawyers for the government also argued that since the innocent inmates, my words, not theirs, of these COVID jails had access to water, some form of food, Wi-Fi, and television, and what I would call yard time outside of their cell, that their security of person was never violated, and that the right of security of person does not prevent individuals from ordinary stress and anxiety. Lawyers for the government also said that it is necessary for air travelers to be quarantined for 3 days while they await their COVID test, because it will teach them to somehow change their behavior and take COVID more seriously if they know if they're positive or negative before they leave the facility, which I guess is an underlying admission that these are re-education camps and a behavioral exercise, and definitely not a scientific medical one. At that point, Jeffrey Rath, a lawyer for a BC marijuana CEO who is also challenging the COVID jail system, objected to the entire argument and reminded the government lawyer that she was actually not a behavioral psychologist. And one last point I want to make here. The government also argued that the 3-day incarceration in the COVID jail, something akin to a routine airport screening or luggage search or pat down, that is necessary screening for air travelers now. Justice Crampton pointed out that there is absolutely a qualitative difference between a pat down and 3 days of confinement against your will. Court is in break for lunch. It wraps up at the end of the day today, and after that, we'll get an update right from the horse's mouth, right from our lawyers about how court went. So stay tuned for that. And if you'd like to fund our legal battle against these COVID jails, where innocent people are subject to a 72-hour airport incarceration for the crime of just trying to come home to their own country, please donate today at nocovidjails.com. For Rebel News, I'm Sheila Gunn Reid. If you'd like to help us fight Justin Trudeau's illegal, unlawful, let's try that again. If you'd like to help us fight Justin Trudeau's unconstitutional COVID jail system in court, please donate today at nocovidjails.com.